let me go to the bankruptcy code to talk about a particular kind of a debt that is not dischargeable. And that is a debt that is the result of doing willful and malicious harm to a person. And then if it's not Chapter 13, to a person or property. So that means you've got two prongs. The injury has to have been the result of malice, and it has to have been willful. So if the creditor can show that the debt was the result of willful and malicious harm, then the court will determine that that debt is not dischargeable. Now you'll notice I've said the creditor has to show this. This is a kind of debt that is dischargeable if the creditor takes no action. So the debtor files the bankruptcy case, lists this debt, and now the creditor has a choice. Does it want to challenge the discharge of the debt or not? This is one of those debts where the creditor has to challenge, and it has to be successful in challenging. Otherwise, the debt will be discharged. This is in contradistinction to something like a non-dischargeable tax debt. The IRS isn't going to mount an action in the bankruptcy court to determine non-dischargeability because the statute's clear. But this is one of those things that's very fact-specific. So the creditor, based on the filing of the case, has 60 days after the date first set for the meeting of creditors under Section 341, and that meeting usually takes place something on the order of a month after the filing of the petition, to initiate an adversary proceeding to challenge the discharge of the debt. But remember, the creditor is going to have to show that the injury was the result of willful and malicious harm. And there's a horrific U.S. Supreme Court case in which a doctor was guilty of malpractice. There's no other way to put it. And as a result, his patient lost her leg. Well, she got a judgment against him. He filed a bankruptcy. And the case ultimately went up to the Supreme Court because she challenged the discharge of the debt. And Ruth Bader Ginsburg was the one who authored the decision. I'm sure she gritted her teeth when she did it. But she said there's no indication that this was the result of willful and malicious harm to this woman. It was malpractice. And the malpractice debt was dischargeable in the bankruptcy. So if it's a personal injury case, just saying personal injury doesn't give enough information. So if the creditor can show willful and malicious harm, the debt is not dischargeable. If the creditor can't show that, then no matter how bad the harm was, it is a dischargeable debt. And of course, this doctor, causing the loss of a limb of his patient, was able to discharge that debt.